they have redacted those particular statements for security reasons, in essence, but the state will address the court in relation to that. We then responded specifically to the state's response. We replied on the 16th of July, because we wanted to ensure that the state is fully aware of the accused person's rights and also what the provisions are in relation to the preparation for this particular matter. In our response, in essence, we highlighted the provisions of Section 35, subsection 3 of the Constitution. We further highlighted Section 153 of the Criminal Procedure Act. Now, that particular provision of Section 153 of the Criminal Procedure Act, it reads as thus. Section 153 of the Criminal Procedure Act provides that under specific circumstances, a court that a witness identity be withheld or that they testify in camera. Basically, what we were trying to highlight in relation to this is that only a court can order a witness identity to be withheld or not to be revealed. But the state cannot simply come to us and tell us that we are not going to give you the names of these particular witnesses without any specific court order, exercising a discretion which is not based in law. Because our client needs to know who are these persons who are actually saying whatever that they are saying against him. And if, perhaps for the purpose of preparing for his trial, he wants to actually do further investigations and prepare adequately for his trial, he needs to know the names of his accusers. Now, if the state is withholding this particular information from the accused person, how then are they expecting that accused person will be in a position to actually consult with this particular, prepare this particular matter adequately? Now, there has never been any threats to these particular witnesses. These are not even complainants, because from my understanding, there are no complainants other than witnesses who specifically witnessed a particular incident or an alleged incident. Now, what security reasons? Accused person is in custody. Conditions can be, actually these statements can be made available with conditions that those particular details can stay between the defense and the state. We don't have to reveal that particular information to the media, but it is important that the accused person knows the names of these accusers or these particular witnesses. There is no specific threat, Your Worship. And now, we are submitting, Your Worship, that the state's refusal, and actually them ignoring our email on the 15th of July, wherein we were actually indicating that there is no provision in law that actually allows them to actually redact these particular statements and not provide us with the names of the witnesses. They ignored that particular email. They did not respond to that. It prejudices the accused person in preparation for his trial. It is unfair to the accused person, Your Worship. Accused person is entitled to a speedy trial, and the Constitution says he must be furnished with the information so that he can be in a position to actually prepare for his trial. Now, without valid reasons denying the accused persons this particular information, I submit, Your Worship, that This is an unreasonable delay on the part of the state, Your Worship. And we request that this court, Your Worship, should order that these particular statements should be made available in the form and manner that we have actually requested. Be made available to the accused person so that he can be able to prepare for his trial. Now the situation today is that we have received statements today, and we are expected to actually also consult with the accused persons today. But again, it's not all the statements that have been provided, and our requests have been ignored. This will only just cause a delay. An accused person is in custody, and it appears as though the state does not appreciate that particular fact. They are not treating this particular matter with the agency that it requires. These statements which we're receiving today, it should have been done a long time ago. It is not explained as to why between the 10th of July when we made this particular request and only today, the 3rd of August, we are being provided with this particular statement. Your Worship, this cannot be an acceptable practice, Your Worship, in relation to ensuring that justice is not delayed, Your Worship. That is all that I have to submit at this stage, Your Worship. Scott, please.
Thank you.
Thank you, Your Worship. An objection is related to that the state is in fact refusing to hand over the statements which are attack statements. Your Worship, after all the contents, the documents handed over to the defense requested that certain statements should be tied. That was done, Your Worship, and these are the statements that were given this morning. And with regard to painting a picture that it is about 10 statements that are outstanding, that is incorrect. What is outstanding is the names and the personal information, not the defense. Your Worship, I would refer the Honorable Court to the Criminal Procedure Act, section 144, subsection 3, paragraph A, and subparagraph specifically that the state does have a discretion to withhold names and addresses. Your Worship, I just want to respect that the only statements that my learned committee is saying is they are saying only the names and the addresses. My learned committee is saying all the statements. Now, what he wants is the names of the witnesses. The other reason that the state embarked on this journey is because during the bail application, there was a threat that was made to one of the state witnesses. In fact, that is the witness that was in the bail. And the name and address of that witness was given, and then that witness was visited by the wife. We therefore we are trying to avoid such incident from happening. Your Worship, the state further submits that it is not correct that the state is in fact delaying the start of this matter. That is not correct. Your Worship, if the Honorable Court is of the view that the state is delaying this matter, the court may then order the state to reveal the names of those people. However, that will not be in the interest of justice if those names are being revealed. And my colleague have also cited the Constitution that is the right of the accused in treatment. Your Worship, I submit that the right cannot be temporal, only by the name, not submitting the name. The statement has, I think it's A6 and A5, there are about 4 statements. They have been numbered, so I really don't know whether the name had the defense in the consultation. Your Worship, it has also been indicated that there was an email that was sent. I responded to the email. The second email was now saying we demand that we should be given the names of the trustees. I then decided that, well, I think I have responded, I have responded to second email.
Wouldn't it be better if the name is provided, but not the address of those witnesses? Would it not serve the purpose of trying to protect the residential address and the whereabouts of the witnesses?
Your Worship, I think that might be a dangerous. Why am I saying that? When the incident had taken place, one had to go around and investigate who is so-and-so, where is so-and-so staying, the identity of the witness might then be revealed, and also the where the witness is. That is the problem. That's a purpose.
Yes, kind of.
Your Worship, I'll be short. The state should not mislead the court and indicate that there was a witness which was intimidated. That is not true. Your Worship, there is no state witness in relation to this particular matter that was ever intimidated. The accused person in this matter is not even facing any particular charge for intimidation of any particular witnesses. This particular amendment which has been made, it emanates from a witness, or rather not even a witness, or rather a person who is a neighbor of the accused person, and that particular person was rather irritated by the accused person's wife who was visiting her. There is not even any allegations in the statement of that particular witness that this witness was sexually intimidated. It is a pity that this court is not privy to the statement of this witness. But this accused person has never intimidated any of the witnesses, Your Worship. Your Worship, I submit, Your Worship, that the names alone again, they will not serve the interest of justice for this particular purpose. Accused person needs to be in a position to investigate and know that if he wants to disprove any of the amendments which have been made by the witnesses in those particular statements, he must have enough information before him so that he can be in a position to disprove that particular information. And just so we highlight, this is not a crime wherein it is murder or robbery against any particular person. We're not dealing with such a situation wherein there was someone who was actually murdered or attacked in relation to this particular matter. It is a different kind of a crime. The allegations are that it was a crime against the motor vehicle. That is it. So what informs the state that these particular witnesses will actually be threatened when there was no threat upon any particular person in relation to this particular crime? Hence, we are submitting, Your Worship, that this request by the state is unsubstantiated, Your Worship. And yes, the state did not respond to us, even though we were demanding. The state had an obligation to still respond to us and inform us that they stand by their initial email, if that is what they stand by. And then regarding the delay, it is evident from their own submission that they gave us the statement this morning. Is that not an unreasonable delay? It's a concession by the state that they are delaying this particular matter. That is all, Your Worship.
I do not. Okay.
The issue of the intimidation, there's a docket that is involved. There's a docket that is registered with the Mabani. So one cannot say it is just an allegation. Worship, with regard to the statement that were given this morning, those statements are statements that were merely typed. The defense, they were in possession of those statements.
What is the purpose of disclosure? Isn't that it's to allow the accused to prepare for trial? In other words, to provide him with enough information to prepare for trial in order for him to be able to have a good defense in this case. So what's the problem with the names of the witnesses not being disclosed in the statements? What effect would it have to him preparing for trial?
Your Worship, on our side, it has the effect of accused person verifying the identities of these particular persons, verifying this particular person's whereabouts on those particular date, whether they were at that particular date and time of the incident and observed what they have indicated in this particular statements. Accused person in this matter want to ensure that wherever it has been placed before this honorable court, or rather during trial, it's information or statements of witnesses which are existent and not necessarily being fabricated by the state in order to create a case against him. That is what he wants to investigate. That possibility of a fabrication, it exists, and that is actually the case that the accused person will be putting before this honorable court. So he wants to be in a position to investigate these witnesses. And denying him that particular opportunity, then he will not be in a position to actually challenge all the evidence that has been placed before him, Your Worship. Your Worship, may I just have a minute just to approach the accused person? Yes, Your Worship, that is all we have to submit at this particular stage.
Counsel, is there anything else?
Your Worship, I heard something that my colleague says that they would want to or interview those witnesses. Meet with those witnesses.
And I never said that. I would have stopped him there and there. Is there anything else that you wish to?
Nothing, Your Worship.
You know, at first, this kind of application should be done in the form of a request for further particulars, but it doesn't matter because you already started to bring this application for disclosure of the names and the address of the witnesses. But of more paramount importance is that the safety of the witnesses is very, very important to this court. You know, and whenever one deals with matters of this nature, one has to be very careful in that the lives and of the persons who are to be witnesses are not jeopardized. And under circumstances, I think that it's adequate for the state to provide them with the content of the docket. In other words, what is it that is contained in the docket? The names and the addresses are protected for good reasons, because there are cases where persons' names and addresses have been revealed, and the next day we see on the news and we hear that those persons have been eliminated by way of death, being killed. And that's the most important thing in this court. Under circumstances, I would then order that the state provides the defense with the outstanding statements of the witnesses that they intend calling in this matter. I think there are how many statements that are outstanding? 3 statements.
Your Worship, from my calculations in relation to the email that I received, it's 4, because we requested some 10 statements, Your Worship.
I hope that those statements are also in the possession of the state. If the state doesn't have them in their possession, then I cannot make an order that they provide something they do not have in their possession. But under the circumstances, you indicate to them, because you should have done it by way of a request for further particulars. Under circumstances, I would order that the state then provide them with the remaining statements of witnesses who might be used in this trial. Okay, if indeed they are outstanding witness statements. Okay, provide the defense so they can prepare for trial. But I would not make an order that the names and the addresses of those witnesses in those statements be revealed at this point in time. The application for have those names and addresses revealed is dismissed. All right. Yes, let's move forward.
Your Worship, I think we'll have to have the matter remanded for my colleague to consult, and then.
And you must provide him as well, state.
Your Worship, I will give them the same statement because I've given them everything. I will just give them the same statements.
But
because what they actually want is the names. That's why they are saying those statements.
The names, we've already dealt with the issue of the names. We are dealing with it. They say there are 4 outstanding statements. But how do you know there are 4 outstanding statements if they are not in the docket?
Exactly.
Can you clarify that?
Your Worship, the reason we were saying 4 is because the email, we have not gone through our request against what is contained in this particular email. Simply because of what I've indicated, that we have received this particular email today. So we still need to...
But are you shooting in the dark? Are you shooting in the dark? It seems to me that you are requesting a statement that you have not heard or seen.
Your Worship, we're not shooting in the dark. We can actually ask that this matter stand down, look at the information that they've sent to us against what we have requested in our email, and then we can be in a position to indicate clearly to the court as to what is it that is still outstanding. Because the problem is the state gives us information minutes before the matter is called. So it doesn't give us an opportunity to actually...
What I propose is that I'll give enough time for you. I'm going to adjourn this case, okay? You and the state advocate just compare what documents we have, what documents are outstanding, and see what is it that needs to be disclosed to the defense. Okay?
It's in order.
It's better that way. Okay, Counsel? Right. Okay, give me a date then. I'm going to adjourn this case so that you can then be able to prepare and look through your documents and see what is it that was standing.
I don't know whether a week will be enough.
Give them 2 weeks. 2 weeks is fine, I think. At least that will be enough time for them.
Your Worship, my approach. Your Worship, we have agreed on a date, which is the 20th August. As the court justice.
Is that the 20th suitable?
Thank you, Worship. Your Worship, we have agreed on the 20th of August, Your Worship.
Okay.
Your Worship.
And in future, make use of Section 87 when you're requesting further particulars. It does that. If you
We'll do
request
so.
for the particulars, come Section 87, okay?
We do so.
All right, this case postponed until 20th of August for full disclosure. Court number 23, you are in custody. Thank you. All right.
Thank you, Worship.
All right, thank you. Court will adjourn.